Welcome, everyone, and thank you for joining us today. My name is Ibikunle. I'm the team lead arbitration at Olaniwun Ajayi, Lagos. I also double as the Young ICSID Regional Delegate for Sub-Saharan Africa. And together, I also have with me here Dr. Paul Kimani, my co-delegate for Sub-Saharan Africa. We would like to appreciate and welcome the speakers to this ICSID session, starting with Oladimeji, the Supervising Legal Counsel of ICSID over Sub-Saharan Africa for Young ICSID Sub-Saharan Africa. And we also have the distinguished Professor Banifatemi, an established professor and founding partner at GBS Paris. And we also have the pleasure of Mrs. Adedoyin Rhodes-Vivour, the distinguished senior advocate of Nigeria and partner at DRV Lagos, Nigeria. And we also have here the participation of Jane Gichuru, our rapporteur for this session. As you're aware, today's session is basically about ICSID mediation. This is an emerging area, and this conversation is essentially to beam some light regarding the legal framework surrounding ICSID mediation, and also talk about the law and practice around the subject. So in terms of structure for today, we will start with a presentation by Oladimeji, the legal counsel from ICSID, who will take us through the legal framework of ICSID mediation. Then after that, we now have the panel section where we're going to be talking about the practice of ICSID mediation involving Professor Yas and Mrs. Adedoyin Rhodes-Vivour, which will also be moderated by amazing Ikpala, team lead dispute resolution at Olaniwun Ajayi, Lagos. Now, before yielding the floor for Oladimeji to take us through the presentation, I would like to say some things regarding Young ICSID, introduce Young ICSID to us. Young ICSID is an arm of the ICSID, as we know it, and it was established in 2012. It has free membership, and it's open to young professionals below the age of 45. And the purpose of establishing Young ICSID is to advance professional development, career development for young lawyers, and also to provide a platform where young lawyers can talk, can discuss, and also network with themselves and people higher up there. So having laid the background and spoken about Young ICSID a bit, I think I would like to yield the floor for Dimeji Ojo, who will take us through briefly the ICSID mediation legal framework, and afterwards the panel session will follow. Thank you so much for your time. We trust that you have a very engaging participation today. Yeah, Dimeji, please, you can come in.
Good morning, everyone. It's a pleasure to be speaking with you today. I'm going to share a couple of slides. Please let me know if you can see them. Yes. And so over the next 15 minutes or so, it will be my pleasure to set the stage, as it were, and provide you with a brief framework of investment mediation at ICSID. For the benefit of those who may not be familiar with our institution, ICSID was created in 1966 and is one of the 5 institutions that make up the World Bank Group. All of these institutions play a different role, but they all contribute to the overall mission of the World Bank, which is to foster international development and alleviate extreme poverty. Now, ICSID's role in that work is important. What we do is, by helping our member states create and maintain stable investment climates, they are able to leverage private investment, encourage international economic cooperation and development. And this is a key aspect of the World Bank's mission. Effective dispute resolution is vital to this work because it ensures that states and investors can maintain positive working relationships, and that helps retain investment. It helps to ensure the continuation of investment projects, and it ultimately benefits both sides, so the investors and the states. This slide shows you several of the dispute resolution pathways that are available at ICSID. It's a matrix that discusses what's available to who. So on the left, you'd see contracting parties being party one, the contracting state being party one, then the investor being party two, whether the investor is of a contracting state or not. You'd notice that, of course, ICSID mediation is available in all possible permutations. As a dispute resolution pathway, investment mediation offers interesting opportunities, potentially shorter and less expensive proceedings, with outcomes that are entirely dependent on the parties' agreement rather than imposed by an arbiter. Of course, there are challenges, and I'm sure some of those will be discussed during the panel later in this session. Today at ICSID, the administration of mediation proceedings is done under the framework of our mediation rules, which were introduced in July 2022. Under the rules, the ICSID Secretariat is authorized to administer mediations that involve a state or a state-owned entity or a regional economic integration organization, and for disputes that relate to an investment where the parties have consented to bring those disputes to mediation at ICSID. The rules contain no nationality requirements and no ICSID membership requirements. This was deliberate. ICSID member states wanted to offer mediation procedures for a wide range of situations, and so they've deliberately made the scope of these rules broader than the convention or the additional facility. In keeping with the flexibility of the rules, it is actually possible under the rules for one party to request to mediate, and for that request to only contain an offer of mediation, not necessarily an agreement by both parties. And the Secretariat will assist with transmitting that offer to the counterparty. If that party agrees, and then you have a mediation. If not, then it ends there. For the parties, the decision about what pathway best suits their needs requires a comprehensive assessment of the dispute, all of the stakeholders. And because mediation is not limited to a particular type of dispute or economic sector, what's important are the questions that you have on the screen. I think most importantly is there a willingness to negotiate? If the answer is no, mediation certainly wouldn't be suitable. If the goal for one party for other reasons is to obtain a ruling, a binding decision from a decision-making body, mediation also wouldn't work. If the parties want to obtain some interim relief with some urgency, mediation also wouldn't be the right pathway. If the parties are willing to reach an agreement and they are open to negotiating and they're concerned about time and cost, then mediation is likely a good choice. It's important to keep in mind that these considerations may change over time. And because that's the case, mediation also is useful either before a dispute has arisen, when you have a problem that's not yet escalated into a dispute. It's also useful while you already have a dispute ongoing in other fora. From our point of view, the benefits of choosing mediation are that it's an informal process, and so it's much more flexible. The parties keep control of the outcome, and whether there's a settlement or not, the parties are able to decide what the outcome is. Mediation is not a commitment to settle necessarily, it's a commitment to negotiate. And so the parties always retain the opportunity to get up from the table and walk away. The approach with mediation is, what is it that I, whether it's the state or the investor's perspective, what is it that I would like to achieve? And what that helps with is it opens up customized creative solutions, as opposed to a remedy that's prescribed by the law and usually would be limited to the payment of compensation. The parties are able to design what their future relationship would look like. I said earlier, and this is all that this slide illustrates, that mediation can be used at any point in the dispute life cycle. And so on this slide, the chart runs from the agreement or the establishment of an investment all the way, if you have an arbitration, to an award. And negotiation and mediation are available to the parties from the beginning all the way through the end of that life cycle. So before or after a notice of an intention to arbitrate has been issued, during arbitration proceedings, and even after an award has been delivered and is in the enforcement stages. This slide compares the procedure, and I'm going to skip over it quickly because I want to talk about the core of the process, which is about the conduct of the proceeding. So typically how the mediation procedure would run is a request is registered, the parties agree to the appointment of a mediator. It's usually one or two, each of which are appointed by agreement of the parties, which is very different from the way an arbitration would work. The parties would have provided brief initial statements, and the mediator will conduct initial meetings, and then a first session with the parties to determine the mediation protocol. If you look at our mediation rule 20, it lists some of the items that are covered by the mediation protocol, so including the organization of meetings, any agreement by the parties to suspend any other proceedings or not to commence any other proceedings while the mediation is ongoing. But then you come to the conduct of the mediation, which is what's in the center of the slide. And that process starts out with just the mediator trying to gain clarity about what the disputed issues are, what the parties' views on those issues are. And here, legal analysis and the parties' other priorities come into play, because very often with these disputes, there are economic, financial, and political considerations, environmental concerns, governance risks, all which are relevant, but may not lend themselves to articulation in an arbitration. And then the mediator works with the parties to develop possible solutions. And those solutions should reflect both parties' views on the merits, the risks that for both parties, and their other priorities. And so then they work together to articulate and review proposals and counter proposals to adjust to each other's priorities, adjust to each other's risks. And if the parties are able to reach an agreement, then they work out detailed terms. If there's no agreement, they can decide to terminate the mediation and continue in other fora, and they can return to mediation at any time. Quickly, as we said also on the previous slide, mediators are designing a process, and so their work is very different from an arbitrator. So in terms of qualifications, the primary thing that we look for is experience with investment mediation or mediations with government entities. The negotiations in mediation focus on a variety of issues, which are priorities for the parties. And so you want someone who understands the context and framework of investment disputes, but the mediator doesn't decide the dispute. And so you don't necessarily need experience in arbitration. It's not a requirement, although it would be helpful because you're likely to be familiar with all of the issues that will come up. Now, I said earlier there'll be either one or two mediators, but the default is one mediator if the parties cannot agree within 30 days of registration on whether it should be one or two. And the parties are able to ask the ICSID Secretariat to assist with appointment. We don't have a formal panel of mediators, but we do have a list of professionals, and we're able to recommend professionals to the parties if necessary. In the rules, some of the key principles that underpin the conduct of mediations are first, confidentiality. All information relating to a mediation, all documents generated in the mediation are confidential unless the parties agree otherwise, or the information is independently available, or disclosure is required by law. ICSID in particular doesn't publish any information relating to the mediation on its website without the parties' consent. The second is that the mediation rules require ongoing consent. What that means is that either party can get up and walk away at any time. They're not bound into the process, and so there are no default rules that will continue the case onto an outcome even if they do not participate. If one of the parties is unwilling to negotiate, then the proceedings end. The third under mediation rule 11 is that all the discussions are made without prejudice. So as with settlement negotiations, any position taken, any admissions made, any offers made are without prejudice to the parties' respective legal proceedings, unless the parties agree otherwise. The mediators who are appointed by the parties cannot act as whether arbitrator, conciliator, counsel, expert, judge, or witness, or in any other capacity relating to those disputed issues. unless the parties and the mediator agree. And then costs. The costs of the mediation are borne equally by the parties. Each party bears its own costs and expenses. And it's important to note these costs are typically, or at least with what we've seen so far, typically are less than the costs for an arbitration. The mediation proceeding will conclude with the settlement agreement, and the settlement agreements are binding contracts, and so they may be enforced in any way that a contract can be enforced. So whether through domestic litigation, arbitration, on the basis of international treaties which are available to the parties. The agreement is prepared by the parties with the help of their counsel, with input from the mediator, and it includes whatever the parties deem necessary. So guarantees to secure compliance, monitoring requirements, and it will address what the parties' practical considerations are for whatever the outcome is. So if compensation needs to be paid, whether there are any tax obligations arising therefrom, how, in what form, or according to what schedule any payments need to be made, etc. And the mediator remains available. So if the parties want to revisit some of the issues or to gain clarity on some of the details, the mediator is not drafting the agreement, but is able to assist the parties with their discussion. Our final slide lays out what the pathways are for enforcement. So for both ICSID awards and mediator settlement agreements, voluntary compliance is the norm. If enforcement is required, and this makes sense in mediation, particularly because the settlement agreement is the outcome of both parties' input. But if enforcement is required, then the pathway to enforcement will, of course, depend on the settlement agreement. So if it contains a dispute resolution clause that requires either domestic litigation or arbitration, the parties may be bound to do so. If it is an international investment mediation, the parties may be able to rely on the Singapore Convention. If the settlement agreement is embodied in an award, then it will depend on the kind of award. So if it's an ICSID Convention award, the parties are able to rely on the enforcement mechanism in the ICSID Convention, or they would be relying on domestic litigation in the seat or enforcement under the New York Convention and in one of the member states to that treaty. As a final point, let me just recommend, for more information, the ICSID background paper on investment mediation. It's available on the website. It contains very useful practical insights into mediation, into the process and the roles of parties and counsel. With the hope that this summary has been useful, I will pass the metaphorical microphone to Mr. Amazing Ikpala. He'll be moderating the panel this morning, and I look forward to listening to and learning from our very accomplished panelists. Thank you for listening.
Thank you, Oladimeji, for that excellent run-through on ICSID mediation. A very useful refresher for many of us on the call, and more than enough to feed the curiosity of anyone who wishes to pursue further inquiry. Am I audible to all? Can you hear me? Great.
Yes, we can hear you.
Fantastic. Well, Isaac has done us the honors at the start of introducing our eminent panelists, but we cannot say too much about them. Professor Banifatemi, founding partner at GBS Disputes and one of the most prominent figures in international dispute resolution today. I know that Professor Banifatemi delivered the Berthold Goldman Lecture on International Arbitration yesterday, and it's very kind of her to join us today after that, no doubt, exerting but certainly rewarding outing. We're really glad to have you. Thank you for coming. And Also on the panel with us today is Adedoyin Rhodes-Vivour, Senior Advocate of Nigeria, one of the leading figures in international arbitration and mediation on the African continent, with whom I have had the pleasure of doing some work in the past, and I'm really glad to see you again, ma'am. Welcome to the panel today. We will go straight into it. And I wanted to ask first, to start with, Professor Yas, I wanted to ask for some anecdotal evidence as to what your reading is regarding mediation and dispute settlement in investment dispute settlement involving, African or Sub-Saharan parties in particular. ICSID's case law tells us that in 2025, about 24% of all investment disputes which were brought to ICSID concerned African parties. In your experience, do you get a sense that mediation is regarded as a viable alternative or complement to investment arbitration? And what are some of the factors which you think might inform the parties' choice to explore mediation in connection with the dispute?
Thank you. Amazing. And first of all, thank you for having me, both you and Isaac. It's a true pleasure to be here with my Nigerian friends and other friends from around the world. And I want to congratulate Oladimeji for his excellent presentation. It was really very nicely done and really putting out all of the elements that we need for our discussion. And one of the elements that Oladimeji highlighted, I think is important to keep in mind, is the willingness. I think that for a successful mediation, and when I say mediation, I probably would also put in the same bag conciliation, because you do have, in a number of treaties, you also have sometimes conciliation. So to the extent that it's an alternative dispute resolution, which seeks to have a sort of agreed resolution without a final binding award, I think that we can treat them in a similar fashion. Of course, they're not the same, but they can be treated the same in that sense. So looking at that, I have had experience in both investment and commercial arbitration, in mediation and conciliation. I've had both. I have to say that generally speaking, and I'm very happy to see that we have these rules, and that their mere existence hopefully will be a reason why the parties will actually think about that option more than just going to arbitration. In the past, though, my experience has been that when you have in a treaty, an investment treaty arbitration, when you have a compulsory process where mediation or conciliation is the prerequisite before arbitration, it becomes somehow a mini arbitration before the actual arbitration. So it becomes a dry run for the actual arbitration. And then you have the parties really having a big fight. It's the exact contrary of what it should be. They have a big fight testing all of the arguments that will be put in the arbitration, testing the witnesses, testing the experts, and then learning from that process as to how they will improve their case for the arbitration. I've had a few of that type of experience. And it's extremely disappointing, because that's not the spirit of what conciliation or mediation should be. Mediation is really to give a chance to the parties to sit together and try to find a satisfactory solution that satisfies both of them. So this is the general experience that I've had. But I have to say that in coming to African parties, I have found that it's looked at in a much more intelligent way, which is truly using mediation as what it is, which is let's get out of court, do a real out of court, out of arbitration without a binding award and really give a chance to discussions between the parties with the help of a mediator. And that's my most recent experience. And we're talking Sub-Saharan Africa. And that's really interesting because then you see that it can be a true alternative. It can lead to a negotiated settlement of the dispute without going to the full blast arbitration. It can be satisfactory to both parties. But again, for that, and I will stop there, you need the willingness of both parties to go through that process. And that's what we heard from Oladimeji, because you need the willingness. Without that willingness, one of the parties can always go to arbitration and then start that. So that willingness has to be present at all times. It has to be there when you decide to go to mediation and throughout. Now, the second element that I want to add and for discussion is the role of counsel. I've seen situations where the parties want to mediate and the parties want to have a negotiated resolution of the dispute, but counsel are not helping because of different reasons. It can be that counsel are happy to go to arbitration. It can be that counsel wanted really the best interest of their client, think that they have a very good case and want to fight that case for them. So I think that we need to really, for us as counsel, to really look at what's in the best interest of our clients and the party. And the parties should be the ones deciding their fate and how they want to proceed and what they think is best for them, with the assistance of counsel, of course. Counsel, our duties as counsel are to guide our clients through that process, but not to think of ourselves first, but to think of our clients and the parties first, because that's what's important. So I'll stop here for now because and these are elements for thinking, but this is really based on my own experience, including the most recent ones.
Thank you so much, Professor. We learned that it is generally not ideal, or it's not much use compelling parties to mediate. It must be something that's truly organic to them, and they must demonstrate a desire to enter that process and produce a result. And also that you mentioned a point which brings me very nicely to my next question, which is about the way that the role that counsel have in mediation. And I wanted to ask Mrs. Rhodes-Vivour, SAN, what exactly should be the attitude and the role of a party's legal representatives when they're dealing with mediation? We know that most people, when they act as counsel, are familiar with adversarial proceedings where they're defending the client's interests, they're attacking the other party's case. Does that role shift significantly, and in what way does it change when counsel finds themselves acting for a party in mediation?
First of all, I think I want to thank Oladimeji. That was a very concise introduction to ICSID arbitration. Oladimeji, thank you. And I also want to thank Isaac. I want to thank you for all the efforts you've put into making this happen. And I think that's a very important question you asked, because that goes to the very bedrock of whether the process can be successful or not, particularly where lawyers are involved. Even in arbitration, when I do arbitration, I know parties that come before me. I can identify them with a litigation mindset, not an arbitration mindset. And it's just as important for a mediation proceeding, for parties, their representatives, to come with a mediation mindset. The process of mediation is very different from an adversarial proceeding. In an adversarial proceeding, you can be telling your parties, insist on your rights, insist you want billions of damages, insist you must have this done. But that's different in mediation, because mediation is a process whereby parties have voluntarily agreed to mediate the dispute. They want a third party to assist them. It can be facilitative, it can be evaluative, but it's really assisting parties to get to an understanding. And you can call it compromise, although it's not really compromise. It's not like splitting the baby into two. But through the proceeding, a good mediator will allow parties or assist them to be able to really evaluate what they're up to be able to do a cost-benefit analysis. Do we really have to be here? Litigation can be very time-consuming. It can take a lot of money because you don't know how long it's going to go on for. Even if you get a decision in your favor in either mediation or in either arbitration or litigation, one party can still decide to go to court. Then get locked up in the court system, particularly in legal systems that the court system is not that fast. So if a lawyer is really being sincere, that lawyer will look at his client's best interest and really advise the client, be a risk assessor, assist them to assess their risks, be a problem solver. Don't encourage them to get locked up in a dispute for so many years. Let them come to the table with the right attitude. If a mediator is trying to cool their tensions, flow along with the mediator, because the mediator plays a lot of roles. Cooling tensions, getting them to an understanding of what the dispute is really all about. Most times when parties are in litigation, and at times in arbitration, they come with all kinds of claims and interests. Some of them, they don't even think they're going to win. But for some reason, they forget the fact that the longer they keep that dispute in the system, the more expensive it's going to be. A good counsel in a mediation proceeding should be able to say, hey, let's look at the risks involved. How much do you think you're going to pay before the International Arbitration Institution? And I've had to do that many times because I don't believe in locking or assisting parties to stay locked on in their positions, to stay locked in these adversarial proceedings, because it's going to cost them. I tell them, administered arbitration, particularly international, is very expensive. Do you really need this? Why don't you think of it along these lines? What is your real interest? What do you really want? What can you not do without? And then they begin to focus on the real issues between them. But if you have a lawyer or a counsel who is not assisting them in that way, who comes to a mediation proceeding with a lawyer's cap, then you're creating problems for the parties. And when I'm involved in mediation, that's one of the things I do. I let the parties know that this is the parties' process. Lawyers, you're here to assist the parties. You're not here to make things worse. So to encourage them to proceed to settlement, instead of getting themselves locked up either in court through the appellate processes, or after you spend some time on the mediation proceedings, then you come out with no agreement. So a lawyer's role in mediation can be paraphrased as moving from adversarial to deal maker. Be a deal maker. Assist in evaluating and carrying out an objective risk assessment for their clients. Be professional in assessing the relative risks, the strengths and weaknesses of their client's case, and communicating same to their clients. One thing I do in my practice is, if any client comes to me, the first thing I do is do a legal opinion. And I tell you straight out.
We seem to have lost your video.
Oh, really? You can't hear me?
No, we hear you well, but we cannot see you anymore. Okay, I see you now.
See me?
We see you now.
I can see myself on the camera.
Oh, great. Maybe it was mine after all, but apologies for interrupting. I see you now.
So I was saying that so the client, the lawyer has to move from these normal positions in adversarial proceedings to assisting the parties, assessing the strengths and weaknesses of their case, and communicating to their clients. And I also concluded by saying that in my practice, before I take on any arbitration or litigation on behalf of a client, I tell them I have to do a legal opinion for you. I have to let you know what your strengths and weaknesses are, so that you can then decide whether you should go and compromise this dispute instead of wasting your money and wasting your time in court.
Fantastic. Very interesting point about, the fact that your role transforms from a soldier, so to speak, to a deal maker. Yeah. And you're really there to help parties put away the swords and find common ground. In an investor-state dispute context, there are not only commercial considerations that you will have between private parties. There are also public interest concerns, because you are often dealing with public funds, you're dealing with sovereign rights to regulate and things like that. And with arbitration, because it is adversarial, there is at least the impression that someone is looking out for the interests of the states, of the sovereign. And there is some kind of a contest and an impartial arbiter to decide it all. With mediation, because it's a lot more collaborative, is there some risk? And if it exists, is it really there, or is it a matter of perception that because it is collaborative, it compromises matters of, say, transparency, matters of accountability, matters of the public interest and sovereign rights and things like that? Do you sense that tension, and how would you resolve it?
Well, as you were speaking, I was thinking of the issue of confidentiality regards public interests mediation. And I want to say that even in arbitration is meant to be confidential, although inroads are being made into that confidentiality implication. And because mediation, and for instance, if you look at Rule 10.1, Rule 10 of the ICSID mediation rules, it preserves confidentiality in mediation, just like confidentiality is also preserved in arbitration. Arbitration proceedings tend to go to court or some other higher tribunal when one party refuses to comply. We all know what happened. It became all very public and all that. That usually only happens when it comes into the public domain. But in mediation, assuming you enter into a settlement agreement, that means all throughout, a settlement has been reached. Nobody really knows in terms of that settlement, aside from the parties and their advisors. So it could raise issues of public concerns. For instance, when mediation is taking place and it involves public institutions, natural resources where citizens feel they have a right to know, it involves taxation issues, regulation, environmental, then it does raise concerns of, oh, this thing has been totally decided in private, and we, the citizens, don't know of what has been done. Well, the ICSID rules preserves confidentiality, and it says that the proceedings are confidential unless the parties agree otherwise, the information or document is independently available, or disclosure is required by law, which gives some comfort to citizens that may want to know what has happened. We have the Freedom of Information Act, where there's some things that need to be disclosed to the public. But yes, it does and can raise issues of the confidentiality of the proceedings vis-a-vis the parties' rights. What went wrong or what went right? How did they decide? Are we sure that this dispute that involved environmental issues, are we sure it's been decided in the interest of the citizens? Are we sure that our resources are not just being carted away and agreements reached without us knowing? But when you look at it, there are also some protective measures like the Freedom of Information Act, or where it's required by law. If an organization that's involved in public interests does go to court and say, well, we know this mediation, this dispute has been on, we've now been told it's been settled, but we don't want to know what really went on. So that the ICSID rule provides by making it clear in Rule 10 that disclosure, where required by law, will be allowed, irrespective of the confidentiality of the proceedings. So I think that's a balancing that's been effectively handled by and under the ICSID rules.
Thank you, Leonard Siok. We take the point that yes, the confidentiality which attend to these proceedings can be problematic, but there can be legal obligations under local law to disclose. And in any case, the parties themselves can set aside that protection if they feel the need. Excuse me. Professor Banifatemi, one of the things which Dimeji mentioned while he was giving us that wonderful overview is that mediation is suitable where parties are looking for, they're looking to preserve existing relationships. And I mean, I know that you have underscored yourself that the attitude that the parties bring is essential to whether or not any successful result from the exercise. But I mean, there's a young practitioner in the audience who hopes to make a future as, you know, a mediator, and they are confronted with parties who seem to have, whose relationship has absolutely deteriorated. So there's a history of a strain in the commercial relationship between them. Are there any methods, any tools, any tricks, if you like, of the trade that a mediator might employ, or counsel even, to help parties who are really at, you know, in such a difficult situation, to soften their positions and lead them closer at least to a mediated or a negotiated settlement? What practical tips might a mediator or a practitioner deploy if they're faced with a history of strained relations? I know it's a tough one, but
it's a tough one. Do you allow me to also expand very briefly on your previous question, because I want to share actually what I hear from some of my state clients, and to keep in mind how they view the process.
Absolutely, please, by all means.
So I completely agree on the confidentiality point, that it's supposed to protect the process, but at the same time, it's true that you will have, you may have, access to information in certain countries, and it may be there are leaks, and you always have to assume that the process can be, known, or at least the outcome of the settlement can be known. So what is important is that that outcome needs to be in the interest of the parties. And if you're looking now, because your question addressed the states, it has to also be in the interest of the state, because it involves public monies, regulations, and public interest. Now, there's two things I want to say. The first is, you were kind enough to refer to the Goldman lecture that I gave last night. I want to draw a parallel with that case, because what happened in that case, that's the Anglo-Iranian case before the ICJ, International Court of Justice, in 1952. And the entirety of the problem came from the fact that these were all concessions that had been given by Persia to the British, end of 19th century, early 20th century. And these were based on negotiations. And the reality is that the negotiated outcome always ended up being to the detriment of the state. And that's why it ended up before the International Court of Justice, because at some point, the government and Mossadegh said, enough is enough. We have, and that's how the concept of sovereignty over natural resources came about in 1951, when there was a first nationalization ever by Iran of the oil industry based on the sovereignty over natural resources. So that is the ultimate public interest of the people and the state, and really keeping the exploitation of natural resources. The reality is that what really made the point for the state was the International Court of Justice saying, I do not have jurisdiction on a very technical basis, but still it was a binding decision by a court saying, you know what, I'm not going to assess that. And then the agreements by the different governments actually ended up always being detrimental to the state, because there's the element, if we're talking pragmatically and practically, there's the element of, the strength of your argument. Is it really a level playing field? And what leverage do you have in your negotiations? And in that regard, maybe that's the point where sometimes having a judicial decision made based on law is actually a better way of leveling the playing field, because both parties are putting their case out, and you may have a very good case, you may have a very bad case, but at least you can try your best to put your case the best way, and then you may have a chance to have that case decided by a court. So that's where, you know, you have, this is a consideration that's very important when states decide whether or not they will go to mediation and what leverage they have. Now, the second element related to what I just said, and that's really my experience with my state parties, there's an element of accountability that's very important. Sometimes they will say, representatives, it's a current government and it's their regulations that are being assessed and that are being attacked. They will say, you know what, I prefer a judge to make a determination of what I've done and what this government has done, rather than going and negotiating and being blamed for the outcome, which may or may not be in the interest of the public and of the state, and I'm accountable for that. Whereas, you know, the regulation that was adopted, you know, whether it's lawful or unlawful, a court will decide, and I'm happy to wait for that court to make that decision for me. So you see that how we also arrive at that outcome, because it's a question of accountability for representatives personally as to, you know, how they adjudicated that. So that was just wanting to share my own experience in that regard. Now, going to your second, to your question to me, I think it's you have to realize, and I've seen people in positions of mediation, those instances where the conciliation or the mediation became a dry run and a total disaster, where cases where you had arbitrators sitting and really also conducting the process as if it were an arbitration. So testing the evidence and testing the witnesses and the experts and so on. I believe that the qualities of a mediator are entirely different. You can be an arbitrator and be extremely skilled as an arbitrator. You can be also extremely skilled as a mediator. I know some people who have both, but it's not the same skill. It's not the same art. The art of being an arbitrator, where you conduct a proceeding, you have to really be extremely careful about due process, to be very careful about how the parties are heard. The right to be heard is very important. And because you're deciding based on law, so that element is very important, the way that you conduct the process. As a mediator, at the end of the day, it's not so much about due process, it's really about hearing what the parties have to say. So in a very pragmatic way, and the very good mediators I've seen and the best that have developed a true art in that regard is, and I agree with, you know, the presentation and Oladimeji's point at the beginning, which is you have to some extent know what the parties are talking about. You don't have to be super specialized, but you still need to understand the issues at stake. If it's a very complex taxation issue, you have to understand what the parties are talking about. If it's a question of exploitation of natural resources, and these are all elements that we know are relevant to Sub-Saharan disputes, you have to be able to understand, you know, about minerals, about oil, you know, regardless. You have to understand at the very least both the industry and the legal questions that arise, because that's how you want to, you know, reconcile the parties, and hearing one and hearing the other, make sure that you offer them a way to get out of that dispute by having a compromise, because each party has to make a compromise somewhere. It's really different from arbitration in the sense that you can win and lose. It can't be black and white. You put your best case, you win, you lose. But in mediation, you have to make a compromise, and you have to lower your expectation and accept what you can sacrifice, because your interest is in sacrificing this in order to get that, and what is it that you are willing to sacrifice. And the mediator is there to help you get there, and they help you get to that compromise, and therefore they need to understand the issues. But the true skill, I think, is to having an extremely good ear and being able to hear the parties and to translate. What you're doing right now, amazing. To hear the parties, to translate, to say, okay, I understand that you're this is your position, this is your position. So how can we arrive at something that satisfies both? And it's really a conversation where you are much more involved. Whereas as an arbitrator, you're just listening. You can be extremely active and ask questions, of course. But as a mediator, you become part of the process, really. And you really want to bring the parties together and help them shape the compromise that is satisfactory to both of them, with the sacrifices that it involves for both parties, because they will have to give away something in order to arrive at that compromise. So the art of a mediator is very different from the art of an arbitrator in that sense.
Fantastic. I thought it was very interesting what you said about on the first point regarding confidentiality, which is that it is fair to assume where you're dealing with state parties that the outcome, if not the process, will ultimately fall in the public sphere, and somebody's going to look into what has been done. And so it makes sense to proceed with that in mind, in spite of, confidentiality protections that might exist. And also particularly interesting, I think, the point that you make about the mediators, it being important for the mediator to understand the full context of the dispute in terms of the cultural context, the commercial context. And it ties in very neatly with the example that you give about the way that a particular official or a particular government, a particular administration might approach a dispute and say, hey, look, even if I see some merit in this course, maybe it's best for my own long-term benefits that an arbiter gives a decision rather than being seen to have compromised. So a skilled mediator is one who is sensitive to all of these nuances and brings that knowledge to bear in the work that they do. Professor, another question for you, and it's not too different from the one which you have just answered, but it just takes a much more specific issue and how it might affect the mediation process, and that concerns third-party funding. Third-party funding used to be fringe in arbitration. Now it's pretty much mainstream. Everybody has a third-party funder or can find one if they have a strong enough claim. Do you think that has some implication on the viability of mediation? Does it make them, say, less likely to compromise if someone is hanging over your shoulder and expecting to get a share of the proceeds? Or is third-party funding equally viable in mediation as it is in adversarial proceedings?
A lot depends on the terms of the arrangement reached with third-party funder. And my understanding is that most often than not, I'm not aware of all types of arrangements, of course, but these are financiers, and you can imagine that they are thinking of their financial interest. So because they're accountable, also there are little pension funds behind, for example, so they're accountable. So I think that most often than not, they will have in their arrangements a number of different scenarios, and the scenarios will include a settlement by the parties, be it in the form of direct negotiations or mediation or conciliation. It doesn't matter. To the extent that there's a settlement of the dispute amicably between the parties, distinct from an outcome of the arbitration with a binding decision, I think that would be one of the scenarios. So I think that it's not a sort of, to respond to your question, I don't think that it's against the interest of mediation to have a third-party funding, because I think that will be included as a scenario, because at the end of the day, they want a share of what they have financed. If it's through an award or if it's through a settlement, to them, I think it's the same. So if the question I think is how they calculate what amount and what percentage or what portion of what they get in these different scenarios. And then again, each third-party funder can have their own policy and their own way of calculation. That being said, I think that it's much more mainstream today. You're right. It's still in investor-state dispute. It's still a lot used by investors rather than states. Years ago, I was very vocal in Mauritius when we had ICA in Mauritius, and we commissioned at the time a working group on how to finance states, because states also need to be financed because they're dependent, and they always do not have the benefit of counterclaims where they can actually have funding. So that's a true issue. So it's often the investor who will have the benefit of third-party funding in arbitration. Now, the empirical studies or the figures that third-party funders themselves give is that it's 1/10 of the requests that they get financed. So, and then it's, you know, it's so they wanted to have a very good case before they engage and commit, of course, to the case. So as much as it's more mainstream, it's not necessarily easy to get financing for the hardest cases or the more borderline cases. You know, you have to have a very good case, or at least they have to deem that your case is good enough for them. And with that, the last thing I would say, and that goes to the arrangement, and that's one of the reasons why I'm suspicious of third-party funding generally. If I were to give my own approach, and one reason for which I am suspicious is how the arrangement is made and who decides. In the sense that if there's a funding, the funder needs to fund. The funder is not the party and cannot substitute itself for the party. So the ultimate decision needs to be the parties assisted by its counsel. So I'm suspicious of arrangements where the funder somehow becomes as an assignee of the party, and therefore and with a lot of, you know, different questions that may arise as a result of that, including on jurisdiction and admissibility, you name it. But just on the pure from your perspective, the question then is who decides? If the arrangement is that the third-party funder has some measure of decision in the decision to settle through mediation or direct negotiations, to what extent it's truly in the interest of the party as opposed to the interest of the third-party funder, because they will deem that, okay, this money, at least I can optimize my own finance, yes, as opposed to, is it really not better for the party to go and either negotiate further or to wait for an award, because at the end maybe they may have a better solution and better outcome with an award. So that decision, whatever it is, to me, has to be the party's decision. It cannot be the third-party funders. Because at the end of the day, yes, they take a risk. Yes, they have a huge, you know, satisfaction at the end if the party prevails. But they can, I mean, they should not be in the shoes of the parties in that regard. I hope I'm responding to your question, but it's a quite tricky situation, third-party funders.
Very insightful response, Professor. We learn that it is not necessarily an impediment, mediation, to third-party funding. Interesting, the point you make about the availability of funding to state parties. I am sure, I mean, I know many African countries who would welcome the potential of third-party funding for their treaty claims that they have to defend. And you make also the point that it's important for the party to retain some autonomy in respect of the decision to settle, which has to be made when you are involved in a mediation. Very interesting points, which I think tie back very nicely to the point about the role of counsel. These are some of the things which skilled counsel will bear in mind when they are guiding a party who's looking to seek third-party funding in claims which might be suitable for mediation after all. If I may return to Mrs. Rhodes-Vivour, SAN, one of the attractions of arbitration at least, whether it's international commercial arbitration or investment arbitration at ICSID, is enforceability. You can take an arbitral award and you can go pretty much in nearly all the states in the world, over 172 in the case of the New York Convention, comparable number with the ICSID Convention, and you can get a binding enforceable award. You can deploy measures of constraint against a debtor who will not pay. What are your options when you're dealing with mediation?
Continue.
How do I fare as a party?
Thank you. You've raised a very interesting point, because when I first started out in arbitration, mediation several years ago, arbitration was also always being touted as, oh, it's final and binding, unlike mediation that's subject to the parties agreeing, and after they agree, even if a party signs the agreement, what if the party doesn't want to comply, that you might have to start the process all over again by going to court and all whatnot. But luckily, I think the situation has changed. I think it even changed domestically in Nigeria before we got the international framework or the Singapore Convention or the enforcement of international settlement agreements, because the multi-door courthouse changed their rules to the effect that once you finish your mediation process, of course, subject to the fact that you've entered into an agreement, that agreement can then be enforced by the court. So you don't have to go through the old process anymore. Under the Singapore Convention now, which is a convention similar to the New York Convention, it creates a situation whereby there's a framework for the enforcement of international settlement agreements. There are requirements for reliance on such settlement agreements. So we all have to make sure that we're very familiar to ensure that we're in the right place to have our international settlement agreements enforced. You're supposed to submit your settlement under the convention to the competent authority. It has to be signed by the parties. That there has to be evidence that the settlement resulted from mediation. You have to have the mediator's signature on the settlement agreement, much like arbitration, where you have to have the arbitrator's signature on the arbitration award. There has to be an attestation by the institution that administered the mediation, or in the absence of some of those, any other evidence applicable to the competent authority. So you now see that internationally, we even have a framework for the enforcement of settlement agreements which arise from mediation, similar to the kind of framework that we have for arbitration. And the good news also is that within the African context, it's been adopted by, well, that's not a very good statistics. From my last research on it, by 2 African countries. It might have increased by now. And this allows the global enforcement of cross-border settlement agreements, similar along the same lines as the New York Convention. So in the African context, I think we all have a duty as ambassadors of our nation to go and get our governments to ensure that they adopt the Singapore Convention. So I think that clears the way for enforceability concerns of international settlement agreements. Thank you.
Thank you, Leonard Silk. I will speak with my colleague Isaac, who is a great politician in Nigeria, and he will say, well, we have already,
Nigeria is fine.
We are already signatories to the Singapore
Nigeria
Convention.
is fine.
Well, he has.
Yes,
Leonard Silk.
I was going to say that Nigeria is fine because even for the domestic framework, it's also incorporated into AMA 2023. Absolutely. So Nigeria is fine both internationally and domestically. So we should just end the ball. You know.
Isaac will speak with his friends elsewhere on the continent.
So that would be great.
Thank you, Leonard Silk.
Thank you.
Now, when parties, let us say, even the most, and I'm speaking now, this question is for Professor, even the most well-intentioned parties, may find themselves at an impasse. It's just not possible for whatever reason for the parties to reach a facilitated agreement. The mediator is skilled, the lawyers are helpful, the parties are willing, but the math is not mathing, as they will say. How do parties, I mean, Dimeji mentioned that parties can use mediation both prior to arbitration. They can do it before or during. How do parties manage a transition from mediation to arbitration or whatever dispute resolution mechanism it is that they have agreed to, and if they haven't agreed to litigation before the forum, the appropriate forum? What considerations should govern that transition? And are there points which they should bear in mind even while they're mediating, or is that something which you manage when the time comes? Is that a bridge you cross when you get to it?
I think the most important factor is leverage, because again, when you're negotiating, and mediation is very close to that, right? Because you are negotiating with the help of a third party who is trying to get your views closer and to try to arrive at a settled solution. Sometimes, and based on my experience, you can try to create more leverage, and the more leverage comes from different angles. It can be just something that you throw in terms of what you're accepting or not accepting in terms of pure sheer negotiation, or it can be your legal position. And what you're asking is very relevant and very important. I think that and that's what's great in the ICSID mechanism, which is both broad, because you don't need to, it's not an ICSID system, it's just something that everybody can use. And it's important to use it in the middle of the dispute. So you don't have to, and again, that's where those instances of conciliation mediation that I saw, which were not helpful, were those where it was compulsory. So you would have to go through it before you start an arbitration, because it's just a admissibility requirement before you start your arbitration. So you have to go through it. And then the way that the game is played is that it becomes a dry run. If you really take it seriously as a true mechanism to arrive at a solution that is not based on a final and binding award, then it can be at any point in time, just as for negotiations. And as at any point in time, you can run your arbitration in parallel and have a mediation separately. Now, I've seen, it's not recent, but it's sometimes from Swiss or German, and it can be a legal tradition, arbitrators. You may have an arbitrator who will say, well, listen, I'm here to help the parties reach a solution. So it's a mix of arbitration and mediation, where they will tell you, well, at least based on how I'm seeing the case, no party is really winning. And I think that if you sit down and talk to each other, you're going to have a much better deal. And that's something that I've seen, and that's something that can certainly be done. But the trend these days is to really have the mechanism separate, right? So you have your arbitration, and you may have a separate mediation process, either before the arbitration has started, or during the arbitration, or at any point in time. So because it's without prejudice and supposed to be confidential, then so you can have that discussion. And so the leverage that you can create, and then if you have the arbitration running in parallel, you may have a better leverage because your arbitration case is improving. So, and then you have to have a dichotomy in your brain, because at the same time as you're trying to reach a compromise, you are fighting very hard to have a best case based on law.
Yeah.
So creating leverage can be important, because if you're equal and then nothing moves, there's not that many solutions. Either you create that leverage in one shape or form, or you trust your mediator to come up with solutions. And I've seen that as well. Sometimes they try to come up with solutions through get the parties out of a blocking situation, and then it's really a question of how the parties feel comfortable with that, because it does mean for one of the parties again to withdraw a request or to accept something that they were not willing to accept at the beginning. And to the extent that it's a give and take, it's really a matter of negotiation, truly. So there's no really miracle there, but I think that, and that's why I think that the creation of leverage is important, because if you really have a sticking point and then nobody wants to move, something from the outside has to make things move. And that's where, if you have better leverage, you can say, as a negotiation tool, you can say, well, this is why I think I have the better position, and maybe you want to listen to what I have to say in this regard or that regard.
Fantastic. I just wanted to say for our listeners and those who joined us that we're still taking your questions in the chat box, as Paul mentioned, and we will turn you loose upon the panelists in a short while. And so write all your questions down and we will come to you in a moment. I'm having so much fun with the conversation. I think it could go on forever, and I would not miss anything else, not even the World Cup. But I have one more question for each of you, and this one is a general one. We're looking, more and more, mediation is gaining in popularity. It has come a long way from where it used to be. So in Nigeria, for example, Nigeria's arbitration legal framework used to be in a statute called the Arbitration and Conciliation Act. But no one ever conciliated. Nobody knew, no one ever called upon the conciliation aspects of that statute. And when it was revised a couple of years ago, it's now called the Arbitration and Mediation Act. And I think that we're seeing that sort of a trend elsewhere as well. And I wanted to say that from the standpoint of users of mediation, and given increased adoption by states and parties of mediation, what changes would you like to see in future? What improvements to mediation as it currently exists? What aspects would you prune? What would you tag on? How would you modify the system? Is there something you would do differently? Just an open question as we tie up the conversation before we open up to the audience. And so this question will go to each of our panelists. So both Professor Banifatemi and Ms. Rhodes-Vivour. Shall we start with you then, Professor?
It's a difficult question because it's a mentality issue. The mentality is either, full fight, full blast, you go for a full arbitration, and then a lot of the times when I've seen mediation proposed and put forward were from in-house and government representatives, depending on the view that they had that this could and should be mediated. And again, the role of counsel is very important because you want to choose counsel who are having your best interest at heart rather than thinking in terms of, I'm going to have an arbitration that will run a nice course of 2-3 years and then, that's fees. And I'm being very blunt, but, I've seen that as well. And it's not the best approach to a client's interest. I think going back to one of the points that I made, what is important is the timing. Timing is always very important, and that goes to everything, right? So not making it compulsory is one thing, but also to make it available at all points in time is important. So maybe a way of thinking about it. And what I'm seeing is also that, you do have, sometimes you have people who do both, arbitrator and mediator at the same time. there's firms who do both in terms of arbitration and mediation, but sometimes you have very different populations and people who really specialize in mediation and don't do arbitration, and vice versa. So I don't have any proposal in that regard. The only thing I think is important is when you're in a full dispute and you're in arbitration, because that's if you're looking into Nigeria, the starting point is arbitration. And I've seen that sometimes from some sole arbitrators or chairs, it is to offer to the parties and to allow and to really think also that arbitration itself, and that's something that we tend to forget, and maybe I should go to the first point, which is that why people do arbitration is because they want an out of domestic court, neutral dispute resolution, but one that is tailor-made. And the problem with arbitration today is that it has become so I shouldn't say harmonized, but standardized is more it's so you always have the same system. It's become more and more litigious, more and more contentious, and very aggressive. So arbitration has lost its veneer in that regard, because it's lost the ability of the parties actually to sit down and have a civilized conversation, including in court. So, and mediation, and I think that that's why also there's some interest for mediation, because mediation is back to that, going back to having a decent, civilized conversation between the parties and try to find some solution that satisfies both parties. So to some extent, it's what we've allowed arbitration to become, which is, loose by this standardization in the very aggressive style and tailor-made solution. To rather than something that is really what's good for the parties for each dispute. So if we keep that in mind, and for those, whoever it is, keep that in mind, I think that, it's one tool would be interesting, for example, when you have a procedural order with the tribunal to say to the parties, all right, and that's somewhere, so that it's psychologically in the mind of the parties, that the tribunal can say, the tribunal is open. And I've seen that actually done. The tribunal is open to, at any point in time, have hearing from the parties about whether or not they would like to have a mediation or, an out-of-court solution to their disputes, and to encourage the parties to do that if that's they believe that this is in their best interest. So just psychologics is important, because to show that these are not incompatible solutions. It's not either or, it can be both. Even if you have started an arbitration, you can at any point in time go and try to mediate, and then you stop your arbitration if it's in the best interest of the parties, of course. So there are tools. I think that it's the psychological factor that's very important.
Thank you, Professor. Mr. Rhodes-Vivour, SAN.
Okay, thank you very much. I think things are changing. For instance, internationally, we're seeing more of multi-tier dispute resolution clauses, where you have the different steps from mediation, you go to arbitration. We're also seeing ABMED, where you can start your arbitration and you can go to mediation. I think the important thing is that parties ought to be sincere, and their counsel should also be a partner in their sincerity journey. Because at times we do see that there might be a mediation before arbitration clause, but instead of parties to really take advantage of that mediation opening, they don't. And then they use it as a weapon in the arbitration. Oh, it's not all the time. There's sometimes it's really genuine that mediation has not commenced, but at other times it's being used as a weapon. So I think sincerity is very important. For me, I believe that we have enough instruments. Like, look at the ICSID mediation rules. I mean, the arbitration rules, I think that goes as far back as the 1960s. The mediation rules, 2022, I believe, but the rules are there. The encouragement is there. So it's up to parties to take advantage of it, and for counsel to also aid them in their journey. We have the ICSID background paper on investment mediation. Parties should familiarize themselves. People should get even more and more trained, because training is very important. And it's also important in the context of Africa. I think we also have to bear in mind that litigation is foreign to us. Maybe that's why our court system is now so clogged up. and you have cases going on for so many years, because that is foreign to us. Litigation was introduced when we were colonized. Our traditional way of resolving disputes is arbitration, is ADR, which remains valid in our legal system. Now, if you look at the Chinese, that's also their own traditional way. And that's why in China, I believe they call the mediator the go-between that wears 1,000 sandals, because to visualize the act of going up and down and going up and down. So we really need to go back to our roots and try to appreciate the importance of mediation. And it's really up to the lawyers. They should advise their clients. Even when you mediate, you still get your fees. You still get your fees. So encourage them instead of getting themselves locked up in the court system. And many African countries, we also see, are also incorporating mediation into and settlement into their constitutions. For instance, even our own 1999 Nigerian constitution, when referring to foreign policy objectives, it states, amongst others, respect for international law and treaty obligations, as well as the seeking of settlement of international disputes by negotiation, mediation, conciliation, arbitration, and adjudication. So it's all there. In Kenya, they also have a similar provision in their constitution, advocating and encouraging settlement. So I think it's for all of us to take advantage of these constitutional provisions to stop being legalistic and really in the African context. Let's go back to our roots and let parties realize that mediation is an option to spending billions and billions of money in acrimonious proceedings and also having to pay huge payouts. Like when I was in school, I always remember when I was taught, I think when it was in a part one when we were doing jurisprudence, that what is law? That law is nothing more than what the courts will do. So even when you think you have a good case, you can't really be sure you're going to get what you want. So why don't you just be serious within the application contest and get something at least that you can live with? So that's what I just want to leave with all of us. Thank you,
Leonard Silk. I mean, both panelists are unanimous in the view that there's no shortage of suitable instruments, and what really needs to change or what needs to improve is the mindset with which we approach disputes in general and mediation in particular. We have one question from one lucky questioner. I'll just read it out very quickly. And since you already have the floor, Leonard Silk, I would be grateful if you could speak to the question for 1 minute. One minute. Question says, thank you for your insights. It is from Jane. Thank you for your insights, she says. Considering that mediation is conducted without prejudice to parallel proceedings, if parties reach a mediated settlement while court or arbitral proceedings are still pending, what mechanisms are available to ensure the settlement achieves finality and to prevent subsequent relitigation or inconsistent claims across jurisdictions?
Thank you very much. Well, if it's parallel proceedings, from my knowledge, at times parties will actually ask for the other proceeding to be stayed or adjourned. Even in ICSID arbitration, that happens. I don't want to be give out too much information, but I have a proceeding that we've been asked to adjourn consistently because the parties are in settlement. And the ICSID arbitration rules encourages it. So that's a possibility. And then when you're able to, when you finally settle, you come before the tribunal. If it's a tribunal, tell them that we've reached settlement, we'd like it to be incorporated, or maybe you could ask for an award to be made on the terms of your settlement agreement. And then, of course, that award can then be enforced as an arbitral award. So if I understand the question, those are part of the techniques. And even you can ask for a consent award if it's before a consent judgment. If it's before the court, you enter into terms of settlement and you ask the court to record that settlement as a consent judgment. And then it becomes a judgment that can have enforced through the judicial process. I don't know whether I got all the points that were being asked in that question. If not, I can go on.
I am sure you could.
Yeah. So if I got it, so those are the ways. If it's parallel proceedings, there are ways of ensuring that once either you reach a settlement, it can be filed before the court or entered or enforced under any of the international instruments. And if you don't reach a settlement, unfortunately, then you go back to your adjudicatory.
Thank you, Leonard Silk. Professor, would you like to say anything on the question?
Very briefly, it's a matter of the arrangement that's reached in your settlement agreement. And what I've seen, including in the very recent experience, is that indeed a lot of para proceedings, a lot of potential or actual proceedings. So what you try to do is to include in your settlement agreement everything, present and future. So not only integrating the current existing para proceedings, but also those that may happen or not in the future. So that's what makes it very hard in terms of, reaching your mediation process and finalizing it. And that's where you need a very good mediator. But that's what you want to do, is to sort of envision every other type of process that is pending or may come and integrate that into the equation.
Thank you, Professor. Gina, I'm sure that between the Silk and the Professor, your question has been answered in every dimension. And nothing remains now but to extend our deepest thanks to our panelists, Professor Banifatemi and Mrs. Rhodes-Vivour, Senior Advocate of Nigeria. We thank you so much for joining us. I will now, that brings us to the end of the moderated session. I will now pass the baton, so to speak, to Paul for some closing words. Thank you very much.
Thank you, amazing. Thank you very much.
Thank you.
Thank you. And thank you all for joining us today. To our distinguished speakers, Mr. Oladimeji Ojo, Professor Yas Banifatemi, and Mrs. Adedoyin Rhodes-Vivour, Senior Advocate from Nigeria. Thank you for sharing your expertise and practical insights. My sincere thanks also go to our moderator, Mr. Amazing Ikpala, our rapporteur, Mrs. Jane Gishuru, and my co-regional delegate, Mr. Isaac Ibikunle, and the young ICSID and ICSID teams whose hard work made today's seminar possible. Today's discussion has shown that mediation under the ICSID framework is a valuable complement to arbitration. Indeed, we heard from Oladimeji that mediation does not require ICSID membership for the parties. It provides states and investors with an effective means of resolving disputes while preserving the relationships that underpin sustainable investment. A common thread running through today's discussion was that effective dispute resolution extends beyond legal rights and remedies and requires sound judgment, constructive dialogue, and a willingness to pursue practical solutions. As mediation continues to develop across Sub-Saharan Africa, strengthening institutional capacity and familiarity with the process will be essential. Professor Yas Banifatemi noted that mediation, in this sense, can then be a true alternative to arbitration. To my fellow young practitioners, I encourage us all to embrace these tools and to see ourselves not only as advocates, but also as trusted advisors who help prevent disputes, preserve relationships, and facilitate lasting solutions. Mrs. Rhodes-Vivour, Senior Advocate Nigeria, aptly encapsulated this point with her statement or call for the move towards being a deal maker. Young ICSID remains committed to supporting that journey through continued dialogue, knowledge sharing, and a professional engagement. We look forward to welcoming you to future events. Allow me to leave you with one final thought. The future of investor-state dispute resolution will be defined not only by the awards that are rendered, but also by the disputes that are wisely resolved before an award is ever needed. As practitioners, advisors, government officials, and scholars, each of us has a role to play in shaping that future. Thank you once again to our speakers and to all of you for your participation. I hope you leave today's seminar not only better informed, but inspired by the opportunities that mediation presents for strengthening investment relationships across Sub-Saharan Africa. Thank you, and I wish you all a wonderful day or evening ahead.
Thank you, everyone.
Thank you.
Thank you, everyone.
Bye.
Thanks,
Thank you.
everyone. Bye.
Thanks for joining us. Bye.
Thank you.